Good morning, all. This hearing is in the matter of CFI 067-2024 and is being held by way of video conferencing before His Excellency Justice Nasser with the sitting of the hearing taking place in Dubai. Any orders, directions made during the course of or after the hearing will be issued by the registry in Dubai on the judge's instructions. The claimant is represented by Hamdan Al-Ka'bi, advocates and legal consultancy. Lead counsel is Ms. Iman Fathi Faid, and the defendant is self-represented and is Mr. Sami Bennani. Thank you, Your Excellency.
Thank you. So we'll start with the defendant since he filed the application, yeah?
Thank you so much, Your Excellency. So I'm here just to explain the situation about what's happened during this commercial issue. In fact, I'm the CEO of a company in France since 7 years. The creation was in 2016. My work is to propose some luxury service for clients in France and in Europe, in all around the world. So I was a manager before in the Plaza Athénée in Paris, so it was my work. So the goal here is just, I will try to explain me. Mr. Mandelkern, the claimant, called me around May 2023 for the World Cup of Rugby in Stade de France, because the organization of this competition was in France, in Stade de France. I have many network on this place. Mrs. Malika Ksili, for example, is the VIP director of the Stade de France. Okay, and Mr. Mandelkern asked me to find for him like some private lodge for this event, for the first game until the final game. Okay, he asked me step by step at different date. So I managed for him some really good price. I sent to you, I don't know if you have the document, Your Excellency, the document of the invoice that I paid and what I asked to pay for the client, Mr. Mandelkern. I don't know if you see that, Your Excellency.
Okay.
Okay. So if you see, there is like a difference. I pay around, for this competition, around 400,000 euro in total. I can tell you I calculate already the total amount precisely, but it's around 450,000 euro for all this competition, and Mr. Mandelkern pay around 120,000 euro. Sorry. The goal here, and it was like a deal with that I had with him, is to say, because he want to follow only the game with France, and when the France will stop, I need to do a refund. Okay, that was the contract that we have together, and I accept that because it was a client that I want to count in my huge client. And I proposed to him to do like this. He was really happy about this situation. He did the first game, the second game, and to precise something, the second game I offer the totality of the lodge, because with the Stade de France there was like an issue of organization. So finally, because it was not on the good place, I offered to him like more than 34,000 euro. So right now, the situation is really clear. A company stole me some money in July 2023. There is like the report from France, because it's a French company, and I lost 1.6 million of euro. I try to do my best today to have back some money and to do the refund. I never say that I will not refund that, but I didn't close the company. You know, in France, when you have some difficulties, financial difficulties, you can close and explain why you are in difficulty, and finally the debt is erased. But I'm living here in Dubai since 3.5 years right now. I have my own company here too. I'm working with different companies like Altavia, Chaloup Group, United Nations to help Gaza. For example, I produce some bags for Gaza. This one is another part of my work, but I need to pay some charge. I have some cost to pay here, and for the moment, it's really difficult for me to pay this amount. I can inform you that of course I will pay that because I'm working with long contract and long project, but for the moment, it's really difficult for me.
Okay, but tell me about the application.
Sorry.
You filed an application, so tell me what's the application.
Which application you speak, sir, Your Excellency?
You filed an application to set aside the default judgment.
An application to cite the default judgment? Yeah. In fact, there was one point at the beginning, because in fact, what's happened? It's Mr. Astruc, the French lawyer who's taking care of Mr. Mandelkern, spoke with my lawyer, French lawyer here in Dubai. Okay, they have some communication together with my proper email and everything. And when the application starts with the DIFC platform, I don't know why, but my email was totally different. So that's why I never received all the information. I was to the DIFC court personally, physically. I spoke with Mrs. Ouali. She know all the story. I called many times the IT to manage that and to read out that. But before that, I never received all the information because the email, and I don't understand why, was changed. It was not only one letter. It was like instead of gmail.com, it was hotmail.com, and it was not the name, the good order of my name. So I didn't understand. That's why I never received the information before. I received an envelope on my place, and after, when I was informed, I follow all the process.
Okay, thank you, Mr. Bennani.
Thank you, Your Excellency.
Ms. Fayed.
Yes. Okay. For now, I will. At the beginning, I'm confirming that I appear on behalf of the claimant, Mr. Edouard, and at the beginning, I need to make a brief submission in line to the skeleton argument, which is focusing on the defendant's application to set aside the default judgment, which was issued on 23rd of December 2024. At the beginning, I want to highlight the case evidence in brief. The first point is mentioning that on 26th of September 2024, we have filed the claim seeking payment of 154,500 euro. And that was the price of Rugby World Cup seats delivered to the defendant. The claimant delivered these seats to the defendant, and that's why we are entitled for the amount that we have claimed for. And the payment was due since September 2023. So it's almost 2 years, and we are waiting for Mr. Sami to make the payment. And until now, he is trying to talk only about his financial difficulties, and that's why he doesn't want to pay. And accordingly, we did, in good faith, we did a settlement agreement which has clearly mentioned that the amount is due, and even the settlement agreement, Mr. Sami failed to make any payment from it, except one payment only he did at the beginning. And in 22nd of October 2024, the claim form and particulars of claim were served by courier to the address which is mentioned in the settlement agreement. So it's not true at all that Mr. Sami did not receive the claim form and particulars of claim, because we have submitted, if Your Excellency review exhibit number 3, you will find that there is a courier confirmation mentioning that the delivery, which is containing the claim form and particulars of claim, it's delivered personally to Mr. Sami. And I personally received a call from Mr. Sami at the time when he received the courier, and he asked me why I received this courier. I clarified to him that it's a claim and you have to respond to it through the electronic system of the IFC courts, and I confirmed that happened. And that was on the date of 22nd of October, and it's mentioned and confirmed by documents. Third point, I want to highlight that there is no any acknowledgement of service or defense filed within the time required by RDC 13.4. And then on 5th of December, that's why we are entitled to get and obtain a default judgment, and we got it on 23rd of December 2024. And then we are surprised that after 5 months from getting the default judgment, we found that Mr. Sami filed a set-aside application regarding the obtained default judgment. And even after we review all the basis for his application, we found that he is only talking about that the email contained in the claim form is wrong, but it's not related because he received the service through courier and he personally received it on the date.
Yes,
so he should, yes, so he should respond to that as per the law. It's not related that the email mentioned in the claim form is not correct. Okay. Last point in relation to the events, we said on 28th of May 2025 we responded to the application in relation to the set aside of the default judgment, and we clarified our objections to such application. Additionally, I want to clarify that the basis of the defendant's application is only related to that he is not served, but the fact is that he is served and it's confirmed. He is confirming now, and also it's confirmed by the email received from the company, the courier company who has performed the service. And the third point I want to clarify is related to our position. We are maintaining that the service was duly effected on 22nd of October 2024 by courier, and it's received by Mr. Sami in person. In addition, that a certificate of service has been filed to that effect, and it's done as per the rules of DIFC. Additionally, we have the service was carried out in full compliance with RDC Part 9, which clearly permits that the service can be performed personally. And the courier's delivery confirmation shows that the documents were in fact personally served on the defendant. And the defendant has not provided any evidence to suggest he filed an acknowledgement of service or defense within the 14 days, the deadline which is mentioned by the rules. Therefore, the default judgment was issued properly and in accordance with RDC 13.4. So at the end, in light of the facts and the defendant's failure to present any valid legal or procedural reason, the claimant respectfully requests that the defendant's application be dismissed. And it's evident from the documentary evidence and procedural history that the default judgment was lawfully entered and the defendant was properly served and failed to act, and now he seeks to unwind a valid judgment without any compelling justification or evidence. And thank you. That's all.
Thank you, Ms. Faid.
Thanks.
Mr. Bennani, anything from your side?
Yes, please. I would like to reply about some point, if it's possible, Your Excellency.
Yes.
First of all, of course, at the beginning, when I spoke with Mr. Astrug, the French lawyer of Mr. Mandelkern, I tried to do my best because they know the situation, and I paid 10,000 euro, okay, directly to Mr. Mandelkern, and have the proof. After that, concerning the envelope that I received, is true. Of course, I received an envelope, but I received the envelope on the date of, because I have the document, on the 21st of October 24.
Okay.
Right? And apparently, because I don't know all the procedure, to be honest, because it's the first time that I have something like that. But apparently, there was like a deadline between the opening of the case until the reception of this document. And when I received this document, the deadline was over. And why it was over? Because I never received any information from the IFC court before, because my email was wrong. So I will repeat something, Your Excellency. I will never say that I will not pay, because this amount, it was like a contract with my client, Mr. Mandelkern. but I don't understand. It's not, I'm here in front of you, Your Excellency, to say, yes, I need to give back this money and I will find a solution, because I'm a businessman and sometimes there is some issue with the treasury. It's happened. And as I told you, I was scammed of 1.6 million of euro in France. And I have another point, if I can, it's concerning the jurisdiction, because this issue between Mr. Mandelkern and me is a French company with a French client, a commercial issue, and there is no judgment in France. So there is some if I'm not wrong, there is some article with a constitution between UAE and France, apparently concerning this commercial, and I'm not sure that it's true, but apparently to transfer like a commercial issue to UAE, because the jurisdiction is in France, and it's a commercial way with company in France, with a client in France and everything, there must be a judgment in France to transfer in UAE. After, I take my responsibility, of course, and I repeat one more time, offers that I will pay this amount, because it was the deal that I had with Mr. Mandelkern. Thank you, Your Excellency.
Thank you, both parties.
May I add one point?
Yes.
Okay, first point, Mr. Sami is talking about the jurisdiction. I would like to highlight that
this is, Ms. Fayed, this is not a jurisdiction hearing. This is an application whether to set aside the default judgment or not.
Okay.
So this point is, I'll not discuss this point in the in my order, because it's not an application to contest the jurisdiction.
Okay.
It's an application to whether the court should set aside or not, whether the defendant has a valid reason for the court to set aside the default judgment or not.
Yes, understood.
So,
thanks.
So I will reserve this application and an order will be issued in due course.
Okay, yeah. Thank you very much. Thank you.
Thank you, Mr. Bennani. Thank you, Ms. Fayed.
Thank you, Your Excellency. Thank you, Mrs. Fayed. Thank you.